give you a shot. I'll give you another one, Stephen. Don't worry.
Thanks. All right, let's without further ado, let's get this started. So welcome everybody. Thanks for being here. As Dan was just saying, my name is Stephen Nigro. I am the president of the Sports Law Society here at New York Law School, and I have the pleasure of being the moderator here today. Thank you everyone for coming to this amazing panel on baseball arbitration, past and present. Before we begin, just a few housekeeping things. Chris Cipolla, one of our panelists, sadly won't be here today. Hope to hear from him soon though. Moving on, we have a CLE event here today. So in order to get your CLE credits, there's going to be 3 codes given out throughout the time today, one at 25 minutes, one at 50, and then one at the very end. So if you do want to get those CLE credits and you're a practicing attorney, listen out for the code words and enter them into the form that was sent out to you in the email prior. Lastly, just a quick announcement. The Sports Law Society is going to be having another CLE event in a couple of weeks, April 7th and 8th, our 12th annual symposium. Thursday night's going to be online. We're going to have an agency panel, and we're going to have a labor relation panel, which will once again probably be going over the MLB lockout and probably a little bit more in depth on what actually transpired. And then Friday, we're going to be in person for the first time in 3 years, going in gambling. And then we're actually going to have a live NFT making and going through all the legality of it and all that kind of stuff. So it's going to be really great. Hope to see everyone there. So today's panel is going to explore the history of baseball arbitration, its practical use in sports today. And further, we will address some of the resolution methods for determining player compensation used in the MLB. Without further ado, I have the pleasure of welcoming our amazing panelists today. First up, we have Chris Deubert, who is the principal of the law office of Chris Deubert, Esquire, and former general counsel of DC United. Chris is focused on litigation and labor employment issues within the sports industry, building an expertise on both player and club sides. He can provide valuable, cost-efficient services with regard to player and league matters, contracts, sponsorships, and much more. Next up, we got Derrick Maltsby. Derrick is an associate practicing with Frost Brown Todd's corporate law practice group and intellectual property practice group. Derrick serves as a business advisor and corporate transactional lawyer to startups, small-sized businesses, and Fortune 500 companies. Derrick's clients range from multiple sectors, but most notably here, sports and entertainment. Derrick has also established a reputation as subject matter expert in consumer privacy, esports, and social media influencers. Next up, we have Gregg Clifton, who is the principal in Phoenix, Arizona office of Jackson Lewis PC. He is a co-leader of the sports industry group and serves as the editor of the firm's sports law blog. Gregg has extensive experience in the collegiate and professional sports world. He has advised numerous professional franchises on general labor and employment issues, including Title III, ADA regulatory compliance, and wage hour issues. Gregg serves as the lead counsel for several MLB teams in their salary arbitration matters and has represented the NCAA and NAIA collegiate clients regarding rules, compliance, investigatory matters, and disciplinary hearings. Today, Gregg continues to counsel clients in areas of collective bargaining, negotiations, and more. And finally, we got Dan Lust, who is an attorney at New York City office of Geragos and Geragos, and is the sports law professor at New York Law School and taught me almost everything that I know, and the only reason I'm able to probably speak on this panel today. So thank you for that, Dan.
Well, thank you, Stephen. Thank you for moderating.
You're a quick learner then, Stephen, because Dan knows a lot, so that's good.
Or well, Stephen doesn't know how much he doesn't know until this panel. Then we could be the judge how much.
I guess, yeah. So we got a long agenda, which will explore the beginning of MLB arbitration, looking at how to keep players paved the way, Kirk Flood and Andy Mothersmith, and then we'll take a look at arbitration process today. I guess if you have any questions, drop them in the chat, and we'll try and get to them at some point. I'd be remiss to, before we get into it, not talk about the big elephant in the room, as Dan was saying before. Within the last hour or two, we found out that baseball is back. So before we head to the past and how we got to where we are today, I just want to take a minute to kind of ask what everyone's takes are on what's going on, What are your overall thoughts on the arbitration process as a whole and its effect on baseball and your own careers? So Dan, what's going on? And then you get into the rest of it.
Yeah, I guess at a high level, for those that have not been following baseball in the weeds, I had a colleague, I was with her today, and I said, the lockout's over. And she goes, I didn't even know baseball was locked out. So certainly there are going to be some people listening to our panel today. Obviously, they are tuning in to learn about the history of baseball arbitration. But just as we were kind of joking, the baseball gods would have it, Major League Baseball has been engaged in a lockout. This is not I mean, it will be kind of a labor and employment panel today. But for, I guess, our beginners, right, there are strikes that are kind of a employee targeted form of a work stoppage. There's also lockouts that are induced by the owners. So on December 1st, the owners locked out the players, and that was because the collective bargaining agreement expired. So for the last, I was not a math major, but 4 months, right around there, they've been engaged in some back and forth negotiation. So, I guess my high level takeaway, I don't want to take all the good stuff from the rest of our panelists. The baseball, for those that know, has been a 162 game schedule. And, at a certain point, we're getting close to spring training. We're getting very close to, the start of opening days, March 31st, and there had to be some spring training games. So when the players and the owners were starting to reach an impasse, baseball's commissioner, Rob Manfred, who's a Harvard lawyer, I think he was at Morgan Lewis once upon a time. Gregg, you can probably correct me if I'm wrong on that. But he essentially said, well, if we don't come to a deal today, here's our best and final offer. Baseball's opening day will have to be canceled. And then that deadline had to be moved back somehow, and then was moved back again and back again. So here's my big takeaway. Not all deadlines are real in terms of negotiation. Actually, most deadlines are not real unless it's a statute of limitations or some type of summary judgment motion. If you don't accept this deal by this date, it's what we know in as lawyers negotiating deals. More often than that, that's not going to be true. The players called baseball's bluff, and now we'll actually have still a full 162 game season. It's just not going to start on March 31st. It's going to start on, I think, April 6th or 7th. But the players called the owner's bluff, which I think I'm going to call this win for the players. Just not accepting that best and final last offer. But that was my big takeaway.
I'll just jump in for a second, Dan. I mean, I think that the interesting thing you have to follow with Major League Baseball, this has been a pattern historically of some very acrimonious strikes, and there's been prior lockouts as we've seen in other sports. And as you described, Dan, which is 100% correct, there are remedies that each party has that they can utilize pursuant to the National Labor Relations Act. Obviously, the players have the right to strike, and ownership has a similar right, which is to lock out. And the purpose, what was at least announced initially by Major League Baseball, was to hopefully encourage the parties to get together and to speak and to try and negotiate and avoid exactly what's happened over the last couple of weeks, which is essentially a breakdown in communications. Unfortunately for all of us, they've been able to resolve these differences now going forward, which we're going to talk about in a little while. The history of this relationship has been incredibly acrimonious going back to the late 1800s into the early 1900s, and having lived through some of them during my agent days back in the early 1990s. It's a very passionate group on both sides. And we're going to talk a little bit about that history in a few minutes. But the good news is today, it appears as though despite some of this unwillingness over the last couple of weeks, both sides, as always hoped for in negotiations, were able to move forward and to make some movement on both positions to come up with some type of a negotiated resolution, which is obviously good for both parties. And most importantly, it's good for all the millions of baseball fans around the country.
Yeah, Dan, I'll hop in, and I'm surprised on this issue. And first, the background: baseball is known for its tradition and being slow to change, and I think that's gotten baseball to a problematic place where it is today from a fan interest level. And so I think you're going to see some very dramatic changes in terms of on the field. I thought we were going to finally see a sort of groundbreaking change of direction in terms of player control and free agency issues, which will, I think, segue into this panel. But we're not seeing that. The system essentially remains as it has for close to 50 years, which is a little surprising. I thought the players would go to war on that and be willing to strike to have that system broken and sort of reconfigured. And that turns out not to be the case in large part.
I think if I'll jump back in, I'm sorry, go ahead, Derrick, excuse me.
Oh, no, I'm just going to piggyback off Dan. From a macro level, I think across all leagues, right? Not just Major League Baseball, but the National Football League and the National Basketball Association and other various leagues, the WNBA being one of them. You're starting to see a trend of players recognizing their value and players leveraging their value, right? Leveraging their platforms, leveraging their voices, and to Dan's point, calling the bluffs of the owners of the leagues, because at the end of the day, they hold the value. And I think what you see in Major League Baseball is more of that talent, of that leveraging of that platform being utilized to make the changes. And while, to Chris's point, I don't think we saw the radical change this time around, I do think we're going to see more changes to the system over the next decade because of just this macro trend of professional athletes finding their voice, finding their platform, finding their leverage against ownership.
I'll just jump in with one last comment. I think those are very good points, Derrick and Chris. I think the one thing we have to remember, though, is this is a unique industry in the sense that owners can't be players, and players, certainly at least at this point, are not capable of becoming owners per se. So they still need one another, and they still need to find a way to work together and to grow the game. And I think the one thing that I think will hopefully be addressed, as you referenced, over the next decade is trying to find some commonality, despite inherent differences in their philosophies, perhaps, but trying to find some commonality to help both sides work together to grow the game. Because the one challenge that we haven't heard that much recently is the fan base. I mean, at my age, I'm a little older than everybody here. I love baseball. I've been going to baseball games since I'm 5 years old. I'll watch a Little League game if I could. But the generational issues that baseball is dealing with, there's a lot of younger students and a lot of younger people who are looking to alternative sports, frankly. So we need to find a way to turn them back onto baseball. And I think that starts by trying to grow the game together between the ownership side as well as the player side, and finding some commonality to attract more fans and make the game more attractive to the great game that it is.
Gregg, I completely agree with you. And Steven, sorry to kind of like hijack and stick in this moment, but like, as I'm 28 years old, I'm a young baseball fan. I live in Pittsburgh, so it's tough for me here, right? Being a Pirates fan is not easy. But hey, I show up at PNC Park at least 20 times a year, and I enjoy the ball game. But I've been brought back into baseball by a lot of the flair and a lot of the young talent that is unapologetically bringing themselves to the game, right? And sort of bucking tradition, which is frowned upon by the league. You know what I mean? I think of the Fernando Tatis situation, right? Where he broke one of the unwritten rules, and there was this whole debacle over him being him. And I think that the more that the ownership enforces these traditions, these unwritten rules, the more you're going to lose young fans, right? To your point. But I do think, you said players can't be owners, owners can't be players. I do think as we start to see more former players taking leadership positions with the league, we're going to see some of those unwritten rules start to fade, right? We're going to start to see some of these changes that we would like to see occur. And so I do think we're starting to see former players who, from a different generation, but still understand these younger players, understand the swagger, understand the attitude. They're going to start to I think, help baseball, shepherd it into this next generation.
Agree with you, Derrick.
So before we talk too much about the current state of baseball, because I'm sure we could speak about that for days, especially with what's going on. Let's jump back a little bit to the past. And how did we get here? Before arbitration, the teams controlled it all. We were in a free market system. The player's contract lasted about a year, at which point, the player could, the team could either re-sign the player, or they could, if the offer was good, the player could accept it, he could decline it, and the player would have their own rights, or they could just leave baseball forever. But Dan, why don't you jump in now? Because you're the professor here, and give us a little bit more of a rundown.
Certainly, and a quick shout out to Professor Phillips for giving us the idea for the panel. So we'll give credit to the baseball gods for taking a baseball panel on the day the lockout ended, but Professor Phillips certainly, gets the credit as well. So the reason we wanted to pick a topic on baseball arbitration, independent of the lockout, baseball arbitration of all sports, there's only really two in domestic sports. That's baseball and hockey that actually follow arbitration. So we wanted to use this panel to basically be a dissection of how we got from point A to point B. And obviously the comments, from our kind of commentary on baseball are certainly important as to the growth and popularity of baseball. I think baseball is where it is today because of the actions of someone like a Curt Flood, which we'll get into. But really the growth of dispute resolution within baseball has really got it to where it is today and really got the salaries to where they are today. So I think the growth of baseball, and baseball for our sports fans that know, all the other sports, be it football, basketball, hockey, they were all kind of built on the backs of baseball. So even as something as simple as the union, right? The baseball's union has always been the strongest union. So people tend to follow baseball. That said, Stephen, you asked, where we start. The conversation has to start with a guy by the name of Curt Flood. If we were in person, I would probably do a show of hands and I'd say how many people know who Curt Flood is. So I'll pretend that about half of you are raising your hands. So Curt Flood was a very talented baseball player for the St. Louis Cardinals. The guy, if anybody follows baseball, he was, approaching a 300 hitter, a very talented guy. In this day and age, would have had a lot of demand for his services had he ever hit the open market. But at the time that he was playing, right, this was in, I don't know, I think it was in the late 60s, right? He had a relatively long career. There was no such thing as free agency. It did not exist. So I think as the story goes, and Gregg, you can correct me if I'm wrong, but again, Curt Flood, didn't want to play for the St. Louis Cardinals anymore. I think there was an issue. He didn't like St. Louis. There was something wrong with the city, I think, or some type of issue. So he writes a series of letters, but the one that everyone focuses on is this Christmas letter on December 24th of 1969. Curt Flood writes, "After 12 years in the major leagues, I do not feel that I am a piece of property to be bought and sold irrespective of my wishes." So I think they were trying to trade him to the Phillies. He didn't want to go. It was a complex issue. So Curt Flood, historically, and I asked, Stephen will know this because he's joking because I asked a question on the exam, our sports law exam for New York Law School. And I said, who was credited for a modern day free agency in baseball? And I had taught the class that it was Curt Flood. And a lot of my students, was funny. Some, by and large, most wrote Curt Flood, but some wrote Catfish Hunter and some wrote Andy Mothersmith. So I imagine we'll talk about both of them today. But I think by and large, Curt Flood is recognized as the guy that kind of opened the door. And then guys like Catfish Hunter, who played for the Yankees and the Athletics, Andy Mothersmith, who's played for the Dodgers in the 70s, those guys kind of broke it open and shaped the world of arbitration in baseball as we know today.
And then I'll just jump in for a second. Those are all great points, Dan. And one thing to go back, and I think there's one other historic name that we have to mention, we'd be remiss if we didn't, is the name Marvin Miller. And Marvin, while he might not be loved by ownership or historically, he was a union leader who perchance ran into somebody who asked him to be spoken to on behalf of Robin Roberts, who was a famous pitcher with the Philadelphia Phillies going back into the 60s. And Marvin is the one who initially got the players together and helped to create the union, which is now and still to this day, I would argue, is probably the most powerful labor union or one of the most powerful labor unions in sports. And that goes back to the mid 1960s. And of course, what they were dealing with, the antitrust exemption, which arose and had been historically, bantered about and finally was litigated and went to the Supreme Court, where Justice Holmes, essentially gave them the antitrust exemption that is so crucial and has been so crucial for almost 100 years. And he ruled, and he felt as though baseball was not subject to the antitrust laws because, frankly, it was an exhibit and therefore was really not subject, an exhibition rather, was not really subject to interstate commerce. So it all started there. And then slowly but surely, as Marvin Miller became established as the leader of the union with his background as a union leader, they started to chip away at these things. But the federal baseball case, which was the Holmes case, was still the centerpiece for such a long period of time. And ultimately, it wasn't until, as you mentioned earlier, as a few of your students mentioned, Dan, the Mcnally and the Messersmith case, that they were able to utilize a provision in the second collective bargaining agreement, which Miller had negotiated, to get them to arbitration and basically essentially awarded them the right to have the salary arbitration option. So, and again, everyone felt as though the world was going to end and baseball wouldn't exist any longer. And we've managed to survive for a good 50 years almost with the salary arbitration system in place, with obviously numerous tweaks along the way. And as we've seen in this negotiation that just resulted in the deal today, still a very important part of the collective bargaining relationship between the parties.
I'm going to take this time really quick to jump in. We do have the CLE first code. The first code of the night is baseball.
That's a good code. Did you come up with that, Stephen?
I did. It was very difficult to decide. So code is baseball. All right. So thank you so much. So, one of the biggest issues here was really like these antitrust challenges that was what Kurt Flug was arguing, and it worked its way up to the Supreme Court. What was he challenging exactly? What was this reserve clause? Could you tell us a little bit more about it? Chris, you want to jump to you? You mind that?
Yeah, sure. So the National League is known as the senior circuit because it's the oldest league. Began play 1876, and somewhere shortly in the time that baseball, the National League started playing, all their clauses, all their contracts, all the owners agreed that every contract would have a reserve clause, which is a provision that gave the team a perpetual right to renew a player's contract. So they would sign their contract, and it would be a one-year contract. And at the end of that term, or sometimes there were multi-year deals, the team had the unilateral option to renew the contract. If the player didn't like the salary that the team was offering, he would be blacklisted from the sport. And the governing agreements of the league did literally have a section called blacklisted. This is what will happen to players that do not cooperate with the reserve clause. The American League came later as a competitor league, and they merged in the early 1900s, and basically is what it still is today. And those agreements, the reserve clause continued. There was the first ever challenge. The reserve clause was a player named Nap LaJoy in, I think, like 1902. Lost. The antitrust laws were not particularly applicable there, but then moving forward, as Gregg said, 1922, Supreme Court says that federal baseball was a new challenger league and was unable to compete because they weren't able to get any players. Supreme Court said, it's not interstate commerce. Antitrust laws don't apply. 1953, there's a Toolson case. A minor leaguer challenges the system again. At that point, Supreme Court says, look, it's been 31 years. The league has been developed based on the idea that it has the antitrust exemption. We're not going to review and overturn federal baseball, even though at the time it was clear that baseball was engaged in interstate commerce. Same thing happens in Flood in 1972. At that point, the reserve clause existed in every other sport. And so it was a way for the leagues to perpetually control the employment of their players. As was being alluded to here, the big change is the Mcnally and Mothersmith cases. And what these players did in the mid-70s, this was designed as a sort of a test case by the Players Association under Marvin Miller, was, okay, the club offers you a contract for, I think it was maybe the 1975 season. You don't have to agree to it. Don't sign it. If you don't sign it, at the end of the season, you've played out your option and you are effectively a free agent. That was the argument. And an arbitrator, Peter Seitz, agreed with them. Major League Baseball, the Kansas City Royals, which was Dave McNally's team, challenged that in district court in the 8th Circuit, and they lost. And so at the same time, collective bargaining was going on, and you have the first collective bargaining agreements in baseball during this period. But again, as Gregg also said, Major League Baseball owners said, they literally said in some of these cases, baseball will certainly fail if the reserve clause goes away. To them, it was incomprehensible that baseball could somehow exist and players having the right to decide where they want to work and how much, and to negotiate for their pay. That obviously was not the case. And instead of just unilaterally deciding player salaries, you actually had to collectively bargain with them under the labor laws. And so that finally happened in the 1970s and has been basically what's been happening in sports for the last 50 years.
And Derrick, do you have any thoughts here? I know, just following chronologically, Andy Mothersmith is another huge name that comes up. And I know he actually went to arbitration after. I know he didn't play with the contract in 1975. And then I believe in the 76 season, he won his arbitration. So I guess, what did that look like at the time? Like, what was the initial arbitration? What was the structure of it, and how did it form to start, I guess?
Yeah, I am exactly the wrong person for this question, because the past of arbitration is not necessarily where I'm at. I'm more of a present guy. So I'm going to give this one to Gregg or Chris or Dan. My apologies there.
No worries. Gregg, we'll jump over to you.
Why does
Derrick,
Phil get to take
yeah,
that?
Dan.
I'll take that question. No, I'm just kidding. I grew up, my dad is a San Francisco Giants fan. So I am, by blood, I'm supposed to hate all Dodgers. But Andy Mothersmith, an interesting story, basically refused to come to terms with the Dodgers. So he kind of forced them to negotiate it. So, it's the early stages of arbitration. I think an arbitrator ended up picking his salary there. Now, what we will get into, I'm not gonna jump on, Stephen, I'm not gonna jump on your shoes here. Don't worry, because Stephen has a nice structure for us. We'll abide by the timeframes. But it was the beginning of final offer arbitration for baseball, right? And this fun concept of the midpoint. But as far as I know, and Gregg and Chris, you can tell me if I'm wrong, I think Mothersmith was the first guy to go to arbitration because Catfish Hunter had kind of a free agency scenario. He was actually a free agent. And I think that's what allowed him to go to the Yankees back in the day. But I think,
Dan, sorry, that's not quite right. So we're talking about arbitration in two different respects. Mcnally and Mothersmith played out their options, did not sign their contracts. They then initiated a grievance arbitration under the then existing collective bargaining agreement. That had salary arbitration at that time did not exist, and this is the important clarification. In the early 70s, there was a collective bargaining agreement that allowed, this is the first ever collective bargaining agreement in baseball, did have an arbitration provision, just like the United Auto Workers and the Service Industrial Union does today. It says if you have a dispute about your employment, you go to arbitration with your employer. It was not a salary arbitration. It was just literally an arbitration. And the arbitrator there, Peter Seitz, decided whether or not those players, Mcnally and Mothersmith, were still subject to the reserve clause, having not signed the renewed contract. And the arbitrator ruled in their favor. Subsequent the collective bargaining agreements after that court decision implemented the first ever salary arbitration system that we basically still have today, which we can get into the structure of as needed here.
Gregg, why don't we jump over to you? Kind of like walk us through what the initial arbitration looked like. I believe it was one panel, one person presiding over it, correct?
I was going to say the one interesting thing about arbitration, which we had an initial question that came up on the chat. A lot of people believe that there is a common law, as I'll call it, that's established through the arbitration process in a written opinion that then can be used in future decisions as a basis to rule in favor of a player and rule in favor of a team. Unfortunately, or fortunately, and I think it probably is beneficial to the system, there are no written opinions. When the process starts and you go into a hearing room, which is essentially a huge conference room in a hotel, the parties come in and the player signs a copy of both contracts, the contract for the number that he submitted, that he seeks to earn in salary arbitration, and then the number that the team submitted that they seek to have the player held to for his contract. So you go through the process, which we'll talk a little bit more about in a minute, but in its initial heyday, there was one arbitrator. And that was obviously a challenging point because you only have one arbitrator, there's only one person's opinion. So as time has gone on and as the collective bargaining process has moved on, they actually expanded the process to have a panel of 3 people. So in today's world, which we'll be dealing with over the next month to 6 weeks now, I assume, we have 3 arbitrators with one person who's designated essentially as the lead arbitrator. And you present your case to all 3 of those, and the panelists, as they're called, and then they render their decision typically within 24 hours of the hearing.
And Gregg, if I can add to that really quickly, obviously lawyers are super used to having, the results of a matter of a case, creating precedent, right? But what I've always found fascinating by arbitration is since there's no written opinion, there's just a result. and the result is publicly known, you know, obviously you find out what the player is going to get paid. It creates an opportunity for creativity for the players the following year, right? To utilize those numbers and to create their argument utilizing the wins of the players from the previous year in their favor, right? And since there's no written opinion, you really don't have an exact reason why that player won. And
Exactly
if you
right.
are a person that likes to be creative, that is an awesome opportunity to really utilize, you know, the argument that you have utilizing those numbers from that past year, or, you know, past 2 years, 3 years, whatever it may be. Obviously, the farther back you go, the less it's persuasive. But I love the creativity that comes out in that process because there's no written opinion. So a lot of people look at it as a negative, or like, oh, that's weird. Like there's no reasoning for it. But I love that there's no reasoning for it. I'm a person that likes to make things up, so it's a lot better that way.
Well, that's a couple great points, Derrick. And the one thing, a couple years ago, I was speaking on this, and as some people remember, there was 1 year when literally there were no arbitration hearings because all the cases settled. And the person asked me the question, gee, do you think the process failed because there were no hearings? And if you look historically, again, going backwards, that was one of the goals of the arbitration system, was to help and to encourage arm's length negotiation to avoid protracted litigation, in our case, arbitration, and the animosity that goes with that process. So I'm only aware of the 1 year where that ever happened, but you know, the way the system, and the other part that people have to realize, which is incredibly challenging as an advocate who's argued on both player side when I was an agent and now on the management side as a representative of teams, that people have to understand you have 1 hour to present your case, and then there's a rebuttal phase. But if you try and think of the law students and the lawyers who might be on the call, imagine trying to synthesize your case, even in arbitrations that I sometimes do in a collective bargaining context, might take a day and a half, 2 days, or 3 days of witnesses and testimony. We have 1 hour to present all your proofs. And what's happened in the world we live in now statistically, the breadth of statistics has continued to expand. So we have more and more information that we have to try and synthesize. And as I always say, try and put it in the funnel and narrow it down and getting into a 1 hour presentation. And the one other thing that I'd like to mention, which has changed, we talked historically as lawyers, when arbitration first began, most of the submissions, in addition to the oral presentation, were written briefs, where you would literally write a brief and you'd make a presentation like you would in any other court forum. And what's happened over time now, we don't use briefs anymore. We use what I would say a slide presentation, which sometimes can be over 100 slides presenting this information in a rapid fire context within the hour. And then you present usually a book, and they have the arbitration panel has those exhibits to review when they try to reach their decision. But a big change over that has been literally the reading in some cases of a brief historically, now to a very rapid, fast moving presentation, which is usually based upon slides that you go over with the panel.
So Stephen, could I hop in and just, we haven't yet fully framed the structure of salary arbitration. Could I go through that real quick?
Yeah, I was actually just going to ask, I mean, why don't we start with how the player even gets there? You know, there's the 3 criteria and stuff like that. Go ahead.
So in other sports, most sports, well, I'll refer to the NBA, NHL, and NFL. Players can become free agents, you know, usually between 2 and 5 years, depending on when they were drafted and their age and things like that. In Major League Baseball, players are not free agents until after 6 years of service time. A Major League Baseball season is 183 days. For every day that they are on the 25-man roster, they earn a day of service time. 172 days in a year on the roster gives you a service year. After 6 service years, you can become a free agent and negotiate with whoever you want for your $300 million contract, whatever. But prior to that, you are subject to the salary arbitration process. Players between 3 and 6 years of service are subject to the salary arbitration process. Then there are what's called Super 2s. These are players with at least 2 years of service time, who I believe are in the top 17% of service time in their year, can also take advantage of the salary arbitration process. So basically, for your first 2 years, you just make the league minimum. It doesn't basically matter how good you are, and clubs rarely have any reason to pay you more than that. Then you enter the salary arbitration process, which we're sort of talking about. And an important thing that I think is interesting is you think, oh, like, well, after 2 years or 3 years, then you're sort of in a pseudo free market, but that's not quite right. So like, I'm a Yankees fan, and so Aaron Judge, after his second year or so, hit whatever it was, 50 home runs. You'd say, well, Mike Trout's making $30 million. Maybe Aaron Judge entering his third year should also make close to $30 million, but that's not how it works. He's only allowed to compare himself in the slide presentation that Gregg's talking about to past year players that are only within 1 year of that number of years of salary arbitration eligible. So if that was the first, it's called 1 TE, first time eligible. So if the first time he was eligible, he's a 1 TE guy, and he can only compare himself historically to players that were 1 TE or 2 TE and what their salary results ever were. So a guy like Vladimir Guerrero right now, I'm not sure exactly where he is in the salary arbitration process, but he's constrained to whatever basically the highest salary ever was for like a third year player, which is probably only going to be like $16 million. And it's only going to be a 1 year deal. So it is still a very constrained market. And that system, that was the system I thought the players may try and break. And I'll explain it like this. If you get drafted by a Major League Baseball club, you may have easily 10 years until you can decide who you want to be your employer and to freely negotiate your salary. That, I think, is unheard of in any other industry in the United States, because let's assume you're controlled for a couple of years in the minor leagues, and then you have 6 years till a free agent. But a major problem and a major point of contention in these labor negotiations was clubs rigging the process of service time. Because as I described, every day you're on the roster, you get a day of service time. So what clubs would do in your rookie year is, like Chris Bryant, and there are many good players who did this.
Yeah, let's give the Chris Bryant example. I think that's a fair one.
Yeah.
So just to piggyback off of Chris. So, at a really high level, there's something, patently unfair. If you're the best player, or we'll say the best employee in your particular field, and you are capped at a certain earning. There's a guy, Mike Trout, who everyone should know that's a baseball fan, best player in baseball. It's basically winning MVPs and getting paid a very close to a minimum salary. And the only thing that was, I guess, pushing him in his favor was maybe the goodwill of his employer at the time, the Angels. If they wanted to give him a few more dollars, they could. They weren't really required to, and he certainly wasn't going to be able to hit and test the open market. So what Chris is explaining, this fun, aspect of free agency, I want to say fun because it's all baseball construct. Mike Trout was not a Super 2 player. He's not a first-time eligible player. He was basically a guy who had not accrued as many days of service as was needed to even reach the arbitration process. So this concept of Super 2, we're very much in the weeds in baseball, and hopefully, Professor Phillips, you're okay with us getting in the weeds of some arbitration here. I feel like we have some arbitrators in the crowd that would appreciate this, but this was a very contested issue in baseball. Chris Bryant, who was, a guy that was at AAA for the Chicago Cubs, ended up winning a World Series with the team. He was the top performing minor league player. He was a guy that, I don't know if maybe people will follow this analogy. He was so talented that in fantasy baseball drafts that year, he was among the top players drafted. So fans recognized that he was one of the top players. Talent scouts that he was the unanimous #1 player in baseball. That player, Chris Bryant, for some reason, even though he was considered a top 100 player in baseball, was not on the Cubs opening day roster that year. And everyone wondered why. And then you start speaking to lawyers who are familiar with the process, because they didn't want him to start his salary arbitration clock. They wanted to wait until the perfect time that he wouldn't be, as Chris mentioned, in that top 17% of second year players. So they waited. And as it turned out, I think he fell, Chris, what was it, 1 day shy of that number? I think he was literally, the Cubs had timed it almost perfectly. They called him up like a month or so into the season, so much so that he missed it by a day. And then the top 17 players, or top 17%, Chris Bryant must have been in the 18%. He missed that window. So he said, if there's anyone that's going to file a grievance for manipulating my, service time, it's me, because it was very clear that I was ready from a performance standpoint to play on the roster. So Chris Bryant, in the grand scheme of things, missed one additional year of salary because of it. And who knows, with career-ending injuries and whatnot, that's a year that he was not able to get back, and a grievance and a challenge that he lost. So if you're not going to win that,
that's the key point, Dan, is that this was a collectively bargained agreement that the union negotiated with ownership. So this was not forced on them. This was done at arm's length, and the parties agreed to this process. So there was nothing that was contained in the collective bargaining agreement that prohibited exactly what the Chicago Cubs did in relation to Chris Bryant. You can accuse them of maneuvering, whatever it is, but the bottom line, they had the legal right that was negotiated and given to them. And Chris Bryant was not the first party to have this happen to. I experienced it when I was an agent with Mark Mulder, who was a tremendous left-handed pitcher, who was the fifth starter who made the Oakland A's. Billy Beane made sure that he called him up for his first start at the fifth man in the rotation. That would give Billy Beane another year of control over Mark Mulder, not only from salary arbitration, but from a free agency perspective. So this has been a common aspect of things. And again, like I always say, when you have a collective bargaining relationship, the parties have the right to collectively bargain. And, as you mentioned, when you have a situation where you have the arm's length negotiation and you have the parties reach an agreement, it is nothing improper for either party to exercise and use the rights that they have, quote unquote, that they've basically negotiated to their benefit. And especially recognizing that once this moves forward, those players are going to be maximizing their value, as we've seen Chris Bryant do, to the tens, if not hundreds of millions of dollars. So again, my only point is this was a negotiated term that after the fact, the union didn't like what they negotiated and their membership was unhappy. So they said, let's go file a grievance and let's try and challenge something that we agreed to at arm's length. So that's my only challenge with it. Do the negotiations. You agreed to it. To try and get an arbitrator involved, I always thought, and I felt as though management was going to win that case simply for that main reason, that they had essentially tried to bypass the process that they had agreed to that term and the impact of that term in negotiations.
I want to add two practical points to the conversation, right? So the first practical point is, you talk about the gamesmanship by the clubs, right? And it, like Dan said, it is an unfair process at times, but there is a practical risk to the clubs behaving in this way because these players are going to remember after, year 6, right? When they do go to the free agency market and you have a Trout situation, right? Where you have the best player in baseball was on your club, right? Well, the Angels had done relatively right by Trout, throughout his years of service. And he, ultimately that's going to help the club obviously land him as a free agent, right? Other than throwing a ton of money at somebody. But, you want to foster a good relationship with the player. And I think that's a part of the gamesmanship that goes into this is there's a calculated risk in how valuable is this player right now? How valuable will this player be when they are a free agent? And, do I care to damage the relationship to a point of potentially no return? The other practical point that I just want to add to the conversation is, when players are going to arbitration, Chris hit it on the head with, like, obviously you can only compare yourself to similarly situated players and be similarly situated service years, right? Beyond that, this is an all or nothing process. You know what I mean? There's like we talked about, there's 2 contracts. You're signing each one. One has one number, the other one has another number, right? So what the process has also done from a practical standpoint is it keeps players from asking for too much, because at the end of the day, you have to go in there and defend your number. You have to go in there and lay out the argument in that condensed time period why you deserve that. And so it's a lot harder to defend these, bigger numbers. And that if you lose, you're going to get that bare minimum or whatever else, whatever they're offering over on the club side. And so even the process itself from a practical standpoint has put handcuffs on the players, has put handcuffs on their agents, their representation, because you have to, make sure that you're able to defend your number. You want a sure thing, or at least something that's within that realm.
That's a good point, Derrick. The only thing I'll add, and I'll let other people speak, is that there was a huge feeling going back to, if any of you remember Charlie Finley and a couple of other owners back then when this whole process started. Their argument was that the player automatically wins in arbitration, and especially with the type of midpoint arbitration that we have, because if you go, let's just hypothetically pick a number. Player wants $4 million, the team offers $3 million, and the player made $500,000 or $600,000 the year before. that player, some of the people have argued historically, is immediately a winner because that player is now all of a sudden going to be going to 3 million in my example. And he has an opportunity to make 4 million if he can prove that he's worth $3,501,000 or more based upon his achievement. And there's one other thing I'll mention. There is certainly not a criteria that's used very often, but there is an argument that can be raised for exemplary performance. So that even though, as Chris properly identified, the 1 year back and forth in terms of comparable nature, you could ultimately still try and argue the unique achievements of somebody. Let's say you had someone who won essentially won the MVP 3 years in a row or won a Cy Young Award 3 years in a row. You can certainly try to circumvent that 1 year comparison by saying these achievements are so exemplary, so incredible, we believe we should bounce outside of that norm comparative basis. So that's still in there. And the players, the arbitration system, I would argue, is clearly a benefit for the players. It's a win for the players because the players, not only does that year impact them, but if a player is eligible for salary arbitration for multiple years, in most cases, usually at least 3, sometimes 4, their starting salary for the next year or the next go round in salary arbitration is where they were at. So you're able to, if you multiply the numbers, you continue to expand upon where you were from the prior year. You bump from that number. You don't go back to minimum salary again, have to reprove it again. You would start in my example at either 3 or 4 million and seeking an increase from above that level. So it's a good victory for the players.
If you guys don't mind, let me just jump in here. I want to get to actually what we're discussing, which is the arbitration process, the dispute, and what's going on. Chris, why don't we go to you? Can you kind of give us a little, I see, said a lot in the chat. Give us a little rundown of what actually, like there's a midpoint you guys are mentioning. There's all these different things. Kind of explain to the group, to everyone here, what's going on, who's on both sides, how it all works.
Yeah, sure. And just for background, I used to for a couple of years when I was in private practice at a different firm, help prepare salary arbitration cases and evaluate cases for a team. But as we've sort of danced around, it's last best offer arbitration, and you now see this used in various industrial contexts, and it's referred to sometimes as baseball arbitration. And as Gregg alluded to earlier, it's been very successful. Because by removing in the last decade or so, there's been a relatively often small number of hearings. Every year, there's probably 100 to 150 guys who are arbitration eligible. And the club and the player begin to negotiate and exchange salaries. And I think it's been said here, but Dan just sort of said, I'll repeat it. The arbitrator is picking, they can't pick a midpoint. In the NHL salary arbitration, they can pick a midpoint. Baseball, they cannot. They have to pick one side or the other. So I think, as Gregg just said, the idea is to be $1 more reasonable than the other side. So if a player thinks he's worth 4 million and the club thinks he's worth 2 million, the arbitrator's decision is basically, okay, well, 3 million is the midpoint. Is this player potentially worth $3,001 or $2,999,000? And depending on which side of that dividing line you fall, you're going to choose for either the club or the player. The functional aspect of this is that it draws the player and team closer and closer in their offers and their eventual offers. And so to the point where when they finally submit their numbers, they might find that they're only $300,000 apart, and then they reach a settlement. And that's what happens in the overwhelming number of cases. And you avoid an acrimonious hearing where the team says, yeah, this guy's okay, but he kind of stinks, which the Yankees did to Gary Sanchez, and he's never been very useful ever since. Or maybe it was Dylan Betances. I could be getting that wrong.
I'll go right back to you, Chris, but Derrick had an interesting point before. You know what's so awkward about the arbitration process that we should address as well? The Yankees are going into the arbitration and telling their current player how terrible he is.
Yeah.
Right. That's the unique part of this, that in order to get the lower number, the Yankees have to say, well, I know you asked for 4 million. We're going to give you 2 million because you much more closely resemble these worst players that earn 2. I know you think that you're close to these 5, but you're actually terrible. So there's this Dylan Betances. The only reason I thought of it, Dylan Betances, he was very clear, former Yankees reliever, that the arbitration process really soured him on the Yankees regime because they went into the room and told him how terrible he was and how many blown saves he had and how many times he gave up these home runs. That's the very peculiar part about arbitration. So it's not really attorney-client. It's your employer has their own lawyer and they're yelling at you from across the table and very to the heart of it, telling you how much they dislike your performance. That I give it back to you, Chris, but that's the oddity of arbitration.
If I can just jump in there for a second, Dan and Chris, I apologize. What you have to realize too, it's what the player is going to be arguing. And I can tell you in Betanzas's case, Betanzas tried to base his number as a closer.
Was that your case, Gregg?
Well, I'm not going to say whether it was, but it might have been. But my point is, the reality is he was trying to compare himself as a closer when he had never really performed in that role. And the Yankees had offered a number which would have really taken care of him as one of the most highly paid setup men. So the challenge, I always say, and as a former agent, I think I can say this with credibility, one of the agent's responsibility is to guide his player and to make the player realize where their value is, at what number. I used to always say to my players, if you think, and it sounds how long ago when I tell a number, if you think you're worth $10 million, we have to have a way to prove it statistically and comparisons and whatnot. If the market doesn't support $10 million, you're not going to be successful. So I think in the Betanzas example you gave, that was a situation where the number that was sought by the agent was really not an appropriate number based upon the performance and the history of performance that the player had had in the role that he was in. So he took a shot. He tried to see if he could establish that. And we see it every year. I mean, it's important from the union's perspective, just to switch gears for a second. The union is trying to establish essentially thresholds. So, and when I was on the player's side, I had a case for AJ Prezinski, one of my initial cases for a player's perspective, and we won the case on the player's side. And one of the arguments at the time that management was making, they were trying to compare him and saying he was not Jorge Posada. And because Posada had had so much success and championships and things like that, what we tried to do was place him in the marketplace below Posada and where he deserved to be based upon his stellar performance. And we were successful because we placed him in the right place in the market. So the only reason I say that is not to pat myself on the back, but just to say the role of the agent, which you cannot underscore enough, the importance of that role is to make sure you try and place your player in the proper place in the salary spectrum for what that player has achieved. And if you don't, then you're going to run the risk of losing. If you do, you're going to have a very good chance of being successful. And one other thing I'll add, which I'm sure Chris was going to add in a minute, and then I'll be quiet, is a lot of things that have happened over the last several years is something we now call file and trial. And I don't know if we're going to see it this year because we're going to have a very tight window of time with the settlement today. But historically, we've seen players and management try to negotiate a settlement, again, the goal of avoiding arbitration. And sometimes historically, you'd exchange numbers, as we call it, and then you'd continue to negotiate. What a number of teams have now employed is a thing called file and trial, so that if the numbers are filed or the numbers are exchanged, the team's perspective is we're going to go have a hearing. And obviously, that is used, I believe, as an effort to try and get players and teams to come together and reach a settlement before. But every year we see some of these teams file and trial, and as Chris just referred to, you might have a very narrow gap between the team's number and the player's number. That's just another strategy, another tactic that we're seeing more readily available to players and teams.
But Gregg, I'm just curious. I think I'm aware, like teams say that, but then when the numbers come out, they still end up settling. Do you think teams stick to the file and trial?
Most of them do. The one exception that I've seen historically over the last several years is a multi-year agreement where they will avoid the file and trial on the 1 year basis only if they're able to agree to a multi-year contract, and then they'll move forward and reach a settlement. But most teams are pretty staunch in their position that if you're gonna make us file a number, we're gonna go to a hearing. So again, that's certainly a philosophy that certain teams utilize.
I just got to jump in real quick. CLE code. The code is lockout. Another one for you, Dan.
Can I guess the third one is going to be, Steve? Will it be settlement?
No, it's actually all three go together.
Hold on. I mean, you cannot tell the codes ahead of time. I got it.
It's not the code, but the three of them do go together and they make sense. So
our participants.
All right, good.
Gregg tried to throw you a freebie. It's not happening.
Well, no one's going to disconnect because this is very interesting, Dan.
That's fair. And a big shout out to everyone that came. 140 participants is a lot for these panels, especially at 5:30. You're going to hear one of my kids in the background, but I know everyone's got.
Dan, 1 second. Someone missed the code. It is lockout. Lockout.
So the one point, we're all, the baseball the arbitration is a very fluid process, right? And as we've been kind of beating around, right? The the salaries have been moving up incrementally, right? There's a concept in arbitration I should mention by point of reference. Chris Cipolla, who's not here, is my former employer. Chris used to work for a company called Excalibur Sports that represented a number of teams that handled, they handled arbitration for a number of. So I worked with Chris through that process. I've also been on the agency side of the process as a 2L. I worked for SFX Baseball, now Ice Baseball, but I've kind of seen it on both sides. Now, there's a concept in arbitration that sometimes is referred to as inflation, and Derrick referenced it earlier. If you use a player that's like 10 years ago, and he has the exact same stats, right? 30 homers, 30 steals, he hit 300, he played right field, he played for the Cleveland Guardians, used to be the Indians. But if you were to do that, and you have the exact same player, you can't use what his salary would be, right? In our court system, if you found the exact case on all fours, right, in the exact same industry, you could use that case, right, assuming it was binding precedent from, the highest court of appeals, or whatever state you're in. You could use that, but in baseball, because the salary, the economics of baseball, that's why we kind of wanted to talk about the larger conversation of the Major League Baseball lockout. The salary, we'll call it the competitive balance tax. It's their baseball's version of a salary cap. That incrementally moves up every year. So the salaries offered kind of are reflected by the economics of baseball. So you can't really look back. I mean, I think 2, 3, 4 years, that's maybe the window until you start to get in kind of hazy waters with inflation. So that's kind of one interesting premise that's not really similar to the court system. And then I'll give you one more that Stephen, we did this in our classes here at New York Law School. Sometimes there are players that come along. Baseball arbitration is based on player comps, player comparables is what it's short for. So if you find, a right fielder, it doesn't have to necessarily be a right fielder, but maybe an outfielder, or maybe a player with the same type of statistical profile, a guy that, works a lot of walks, hits in the middle of the order. Maybe you don't need a positional comp, right? But what is odd, what we had this past year, which I wanted to make sure we brought up, there are sometimes players that come along. It's not that frequently, but that have no statistical comps. We are currently seeing one right now, kind of a unicorn in baseball, a guy by the name of Shohei Ohtani, who is part pitcher, part hitter, and he might be the best of both, right? At least top 10, I would think, in both categories. So a player like that almost has no historical comparisons. So, if you're wondering what players have hit and pitched at a high level, you might think of the name Babe Ruth that comes to mind, but he didn't pitch and hit at the same time. He was a World Series winning pitcher with the Red Sox, and then he was a Hall of Fame hitter with the Yankees. So a guy like Shohei Ohtani, I'm not sure if we'll ever get to that, but that would be a very fascinating case. A player who, Gregg,
I can get that case for management there. Maybe I'll use Babe Ruth as a comparable from a salary.
Good. Well, I'm going to give one. And I know one of our writers for Conduct Detrimental, Britton Yoder's here. He's a law student at Penn State. He wrote an article about this particular case, and they said there were no comps. That's never happened before. And I said, well, there was one in maybe the last 20 years. A guy by the name of Rick Ankiel, Gregg, and Chris.
Sure.
You guys know, right? He was a guy that kind of did it both. He did it in the Babe Ruth way. He was a pitcher and then became a hitter, but didn't do it simultaneously. So we do not have a historical comp. So if and when Shohei Ohtani goes to arbitration, maybe the flaw of this world, it doesn't happen that often. It's a case of first impression. It's literally never happened.
There is.
So,
And that'll be an interesting case if it ever does go to arbitration, because certainly his performance is so exemplary in both areas simultaneously. That'll be a really interesting case. Hopefully one that can be just argued in law schools, and hopefully they reach a settlement on that, because I'd hate to see that one go to a hearing, but we'll never know. We shall wait and see how it plays out.
Dan, I wanted to add something to your first point, and it was something that kind of like I thought about it while it was happening, and then I haven't, my fault, really followed it, and I'd love the panel's viewpoint, is how that COVID year affected this process, because ultimately a lot of players lost potentially a comp year, right? Or a comp due to the way that the process played out that year, or lack of playing out that year. And I haven't really followed along if that's had an impact to this point yet. I don't believe so. Obviously, we might find out, but curious of everybody else's thought on that, Dan. It just triggered in my mind when you talked about it.
I think I'm happy to take it. I think, if memory serves, that because it was a shortened season, that the days were actually prorated. So I'm not going to recall exactly how many days were in that season. As Chris mentioned, it's normally 180. Chris, 183.
Yeah.
So normally that's the number, but whatever they did, this was obviously a point of contention, how these players would be counted. As it turns out, right, we had to prorate it, whatever it was. Stephen, as we're kind of ending, getting towards the end of the panel, I think we spent so much time talking about the lockout at the beginning of the panel. I think what we should talk about, and Chris, I know you had kind of alluded to it, there was talk at this round of negotiation about ending arbitration. There could have been a day where we did this panel. We said the baseball gods aligned. Baseball arbitration still exists. Baseball is back. But the baseball gods almost couldn't have aligned, and baseball arbitration could have been canceled. So we could have had a panel today about something that doesn't exist anymore. There has been a conversation in baseball about ending this arbitration process because it is, in a sense, very favorable to management. Because, right, you're having an arbitrator pick your salary. Why should it take you, as Chris pointed out, sometimes, right, 10 years to become a free agent? Why does that have to happen? In other sports, your rookie deal is sometimes, at least in football, were the highest paid player in the league for a period of time in football as a rookie. And maybe it's not fair. They've obviously now reset that. So football rookies are not the highest paid, but they're paid in the millions, really, in every sport other than baseball. Rookies are paid very close to that minimum salary. Certainly they get a signing bonus for our high level draftees. But if you're I'll make up a number, a 20th round draft pick, right? And you're not, at the top of the line, you didn't get a giant bonus when you signed your contract, and you've now made it. You're the top prospect in your particular team. You've made it to the majors. You didn't get that signing bonus, right? And you're playing on a near minimum wage salary, and you've been playing in the minors, which you're not getting paid $700,000, the new minimum salary in baseball, much, much less. So there's still a world. I still think baseball has work to do on the arbitration system because it is very favorable to management. Not most players. I think the number that we saw, I think 70% of Major League Baseball players actually make less than $1 million. So there was a lot of, phrasing, billionaires versus millionaires when it came to this lockout. It's not really true. So that's why I still think there's work to be done in the arbitration process, because for 6 years as a major leaguer, the free market can't set your salary. So, I think at this portion, I'm happy to give it to everybody, but I think there's a lot of work that still can be done on this procedure. So I don't know, I'll leave it open to everyone, but that's a topic I know, I wanted to make sure we made clear.
And I guess before I comment that, I guess the one word I will use, or two words, is Kyler Murray. And Kyler Murray, as everyone knows, was a high draft pick of the Oakland A's. He decided to forego playing baseball and the potential longer career path of getting to the majors, but also perhaps having a longer career in the big leagues than he will have in the NFL ultimately. But he made the decision, I think, kind of based on what you said, Dan, where he, as the number one overall pick in the NFL draft, he's compensated. He'll be making, I think, $5.5 or $6 million in the 22 NFL season. And that's assuming he doesn't extend his contract by then, which he probably would not have been making if he would have signed as a baseball player. But again, the one thing you have to understand, some of the sports on a comparative basis are inherently different. Baseball has certainly had a traditional system where minor leagues are a part of it, where players go to the minor leagues. Historically, sometimes players would have spent 4 or 5 years in the minor leagues. Now we're seeing, like a Chris Bryant example you used earlier, Dan, the path to the big leagues for those who have the talent is relatively quick, and they get into the system, as we'll call it. And as Chris described earlier about getting ready to elevate themselves into the arbitration process. So it's kind of comparing apples and oranges a little bit. One of the things that I think the union should have been concerned about in this go round is I don't see teams paying more money. They're not having broader payrolls. I see what's happening is a centralization of the money, where fewer players are getting more of the money, and you're eliminating essentially what I'll call that veteran fourth outfielder, the veteran backup catcher, because they're not paying those players the $2, $3, $4 million anymore. Those players are going to rookies, and that's why you're seeing a lot more players at the minimum salary. So that's another issue I've said for years, that when I was an agent, the union issue has to be, it's almost a multiple union situation where, let's be honest, Max Scherzer is a great leader, but he, roughly making $40 million a year, has a lot different interest in a collective bargaining agreement than perhaps a player who is a 1+ player. So there are a lot of challenges in the system. There's no perfect system, but certainly we hope that this agreement today will further positive relations between the sides to help grow the game going forward.
Yeah. Go ahead, Chris.
You go ahead, Derrick.
Yeah. So, I mean, this is sort of a good point for me to just talk about, because I agree with Dan, I agree with Gregg. the future of arbitration, right, and where we're heading from here. And while I think the system does need help, Dan knows this, but my primary practice is, I'm a corporate transactional attorney for tech companies. And so I often get to sit between innovation in sports, NFTs and different things along those lines are very popular right now. But what I've seen is these really, really cool algorithms and technology that is ideally going to help the process that we talked about here in terms of putting together the comps in a more efficient way, right? And so the one that I'll talk about is created specifically for the NBA, and obviously not for an arbitration, but more so for a negotiation between the clubs and the players. But taking an algorithm that takes a player and runs every other player's stats as well as social media and marketing value, and points out the comp almost immediately of the players that they compare to and what their salaries are. And it amazes me how effective that is as a tool. And as of right now, I know it's only been used successfully with one NBA team. But that, in my mind, the innovation that can come to support the players and to allow the players to have more success in the arbitration process, whereas opposed to it could also probably help the teams as well, depending on how far stretched the player is going on what they think they should be paid. But I really do think that we'll start to see different approaches to the arbitration process that are getting a little bit, like Gregg talked about it. It used to be you go in and put on the file a brief almost. Now you're just given a slides. I think we're going to get even more innovative around how to approach the arbitration process, and I look forward to that because I think you can make it more efficient, more fair.
All right, so since we're almost at the end here, I just want to let's do like a 30-second about final thoughts from everybody. Chris, we'll start with you, and then when we're done, I'll give the last code. Chris, go ahead.
Yeah. So what I spoke about earlier, thinking the players may break the process a little bit, so to speak, is I meant that teams, as we've talked about with manipulation, so to speak, can control a player for 7 years or 6 years. I thought players might try and implement a concept like a super 5, that if you are 5 years and 17% of the service time, you could become a free agent. But what they've done, what they've apparently agreed to, I'm reading about, is there's a $50 million bonus pool for players that are not yet arbitration eligible. So first, second, and then third year guys, that is going to be obviously performance based. So the point of there is baseball's happy to compensate for performance after the fact, but they don't want to allow or open up a free market or to increase the degree to which the players are operating in a free market. That's where I thought there would be more of a fight and potentially a bad fight. But I guess the players thought the economics were good enough to back off from that.
Gregg, 30 seconds. What are your final thoughts?
Well, I'm glad we have an agreement. The one thing I'll jump on Chris's point that I was surprised by, one of the things that the Players Association has argued with, I'll call their tax situation, is they wanted to raise the tax threshold to a higher level, in theory, to allow the richer teams to continue to bid on players. One of the things that I had thought was going to be an issue was going to be what I'll call a minimum floor. Right now, a team could have a 25-man roster and pay every single player minimum salary if they wanted to do that. I'm not saying that anyone would, but it's their prerogative. They could do that. So I thought the union, frankly, which was a proposal that Major League Baseball had introduced early on with lowering the threshold, but I really thought the union was going to focus more on that to try and raise the floor and basically say, if you're going to be a major league team, you have to have a payroll at this level and have that payroll increase every year the length of the deal. But obviously that didn't happen. I guess it wasn't important from the union's perspective. So that's the one thing that I was surprised by, that we didn't see them push a little bit harder for with regard to the negotiations.
All right, Derrick, you're up. 30 seconds.
Yeah, no, echo everything everybody said. My takeaway in this is I think the sport is moving forward, right? Slowly, begrudgingly at times, but it's moving forward. And like Gregg said, it needs to move forward because, the traditions, the unwritten rules, the process, it ultimately is going to lead to generational talents like a Kyler Murray. It's going to lead to younger fans not wanting anything to do with the game and looking elsewhere, and that's a danger. So I'm excited to see the game moving forward.
All right, Dan, last up.
So for our baseball fans, this would be the cleanup spot. I'm hitting fourth here. I'll take it.
And the bases are loaded.
Bases were loaded. You guys all got on base, and I'm ready to send us home. So first of all, thank you everyone for joining us. Again, Baseball Gods really did a line. So looking forward, right? I'm not sure. I'm not sure if there's a 4-year deal or a 5-year deal with this collective bargaining agreement. I know someone in the chat I'm messaging, that this was the opportunity for baseball to really end arbitration. And rest assured, I think the players wanted to. I think they really did. But as you can see, there's decades of precedent set into baseball arbitration. You can't just take it away so easily. It's a little bit different than changing the competitive balance tax, or I was going to say moving the DH from one league to another, but I guess that does mess with our records as well. But if they can move the DH to the National League, which we're going to have, our baseball purists, I know it's a pretty crazy concept. It is happening. We can change arbitration at a certain point. And me as a fan of baseball arbitration, I don't want to see it go because it's a perfect blend of baseball and the law. And I will give a quick shout out to our arbitrators out there that do not know. The first, we'll say, sports law competition in the country was won by Tulane Law School. It's called the Tulane Baseball Salary Arbitration Competition. It's open to 1Ls, 2Ls, and 3Ls across the country at every school. And to me, as a young law student, there was nothing cooler than having a mock trial about arguing baseball statistics. So, it's training our young lawyers across the country. We're really learning about our sports fans like myself, like all of us on this panel, are really learning about, dispute resolution through sports. So it's Tulane has a competition, New York Law School for the first year this year has a competition, the soccer competition, Villanova has competition. So it's a very ripe world of sports law competitions. If you'd like to learn more about that, certainly reach out to Stephen, myself, Professor Phillips. We're happy to, advise you on this competition circuit. We're always looking for judges, and we give out CLEs. So we're happy to have you involved.
That's correct. All right. We got to wrap it up. Last code is over. So if you listen to all 3 codes, you now know why we've been laughing. The last code is over. Thank you everyone for coming today. Thank you especially to the panelists here. What a great conversation. And it's going to be an interesting couple of weeks with the CBA now decided and there being an agreement. I know our symposium's likely going to have a panel on this. So if you want to learn more about what's going on, we'll probably be talking on that in a few weeks. So stay tuned for more information on that. And thank you everyone for coming.
Thank you.
Thanks so much for having us. Pleasure to see you guys.
Thanks.
Likewise.